Hi there. So, we've been hearing from a lot of people who are worried about getting exposed to the coronavirus at work because they're still having to go to their job and they feel like their employer isn't doing enough to protect them. And everyone wants to know, if my employer is not doing enough to keep us safe, can we do something about it? And the answer is yes, you can. In this video, I'm going to talk about your legal rights to speak up and potentially report unsafe conditions if you believe your employer may be violating health and safety or other laws. I'm Tim Shaddix. With the Warehouse Worker Resource Center. We're a nonprofit organization based in Southern California. We use education, advocacy, and action to fight for workers' rights. We've mainly focused on warehousing and the logistics industry, but we also work with workers across all sectors. And before I begin, just please note that this video is only meant to provide general information. I am an attorney, but this video is not legal advice for your individual situation. And you shouldn't rely on this information without first consulting with an attorney for advice on your particular case. So, to begin, I just want to remind people that even though we are right now in this emergency situation, it's important to remember that you still have essentially the same legal rights on the job that you had before, and this includes the right to safe and healthy working conditions. In California, we have workplace safety laws that are enforced by Cal OSHA. Now, Cal OSHA hasn't come out yet and said exactly what is going to be okay and what's not under the current coronavirus conditions for warehouses. But fundamentally, your employer has an obligation to keep you as safe as possible. Cal OSHA requires employers to have what we call an injury and illness prevention plan, which basically means that if employers are still operating in these conditions right now, they have to think about how coronavirus exposure to their employees might be happening and figure out how to protect workers as much as possible. And if you want to know a little bit more about some of these best safety practices and health issues that your employer should maybe be thinking about right now, check out a video that my colleagues did that have been posted a short while ago on our sites. It also may be true, in addition to the Cal OSHA rules, that there may be some public health laws that might apply to your workplace right now, since preventing coronavirus transmission in the workplace is obviously an important part of keeping everyone safe. This is why basically only essential businesses are supposed to be operating right now. And both the state and your probably county health departments may be issuing emergency rules and guidelines that in a lot of cases might apply to your employer, and they may be supposed to be following them. So, what do you do if you think your employer isn't doing enough to keep you safe? Well, first of all, if you think your employer is placing you in danger or breaking the law, you have the right to speak up about it. California Labor Code Section 6310 says that an employer cannot fire or discriminate against an employee for making a complaint about workplace safety, either to the employer or to Cal OSHA. Now, in more limited circumstances, you may even have the right to refuse to do hazardous work. If doing the work would violate a Cal OSHA safety regulation and would also put you or your coworkers at substantial risk of serious physical harm or death. That's under California Labor Code 6311. Now, it's generally best to try speaking with your employer about the hazard first, and we would recommend consulting with our organization, Cal OSHA, or an attorney before you get to the point of actually refusing work. And also, while we're on the subject of speaking up at work, just remember that you have the right to speak up about many other issues at work as well if you think your employer is violating the law. Including about things such as harassment or unlawful discrimination, unpaid or incorrectly paid wages, and so forth. So now the next question may be, what happens if you raise a problem with your employer and this isn't enough to fix it? Or, maybe you already know that your employer probably isn't going to listen to you if you bring up these issues. Well, if you think your employer is breaking the law, you also have the right to disclose this information to a government or law enforcement agency, or to file an official complaint with these agencies. This is often what we call whistleblowing, which basically means reporting information about illegal activity. And in California, the main law protecting employees who become whistleblowers about their employer's practices is in California Labor Code 1102.5. And this law basically prohibits employers from preventing workers from disclosing information or from retaliating against workers for disclosing information that is about legal violations happening at work. As I mentioned before, you also have the specific right to make a complaint about workplace safety issues directly to Cal OSHA under Labor Code 6310. Now, the point of being a whistleblower, why would you do it? Well, it's to hope that if your employer is actually violating an OSHA regulation or a public health department order or some other law, that if you file a complaint with those agencies, they may be able to help your well, to make your employer do the right thing and follow the law. Um, and while this whistleblowing is an important thing to do to shine a light on illegal practices, in reality, it often takes more to really make things change. We find that you'll sometimes, in many cases, be more effective in getting something changed at work if you can get together with your coworkers as a group to demand change. And the ability to act together with your coworkers to try to improve working conditions is one of your most fundamental and important rights as an employee. And it's protected under federal law by the National Labor Relations Act, or the NLRA. And NLRA protects the rights of employees to engage in what's called concerted activity, which is basically when two or more employees take action for their shared benefit or protection regarding terms and conditions of employment, such as wages or, say, safety. Sometimes just a single employee can also be protected under the NLRA if they're bringing a group complaint or acting with the authority of other employees, but the safest approach to it is to have at least two employees take action. And as a practical matter, you'll have more power, of course, and be more successful if at least a handful of you act together in talking to your employer or taking some other action. Another benefit to think about with collective action is that you're not as limited as with whistleblowing or filing a complaint by what an agency like CalOSHA says your employer is allowed to do or not do. Even if CalOSHA says a certain practice is technically legal, if you and your coworkers still find it outrageous or unsafe or undignified, you can act together to demand that your employer change it. And this is really how most meaningful changes in workplaces really have happened throughout history and continue to happen now. Um, so now, just to think about, if you're going to speak up at work, to be a whistleblower or to take collective action, we advise you generally want to be strategic and smart about it to make sure that you stay protected. All the legal protections I have been discussing prohibit your employer from retaliating against you for speaking up, for whistleblowing, or for taking action in a way that's protected by law. And employers, can retaliate in many different ways. It's not just by firing someone. It could also be by cutting your hours, demoting them, denying them benefits or promotion, and so on. If they do this and the worker can prove that it was in retaliation for exercising their legal rights, the employer may have to pay them for any lost wages or give them their job back, depending on the circumstances of the case. Now, retaliation cases, unfortunately, can be kind of difficult to prove. So it can be helpful to take some precautions if you're going to take action to make sure you're in the best position to defend yourself if your employer retaliates against you. So in order to win a retaliation case, you normally have to prove a few main things. One, that you exercised rights that were protected by law. Two, that your employer took an adverse action against you, meaning cutting your hours or firing you or something like that. And third, that the reason that your employer fired you or whatever they did was because you exercised your legal rights. Now, to help prove these things, it can be a good idea to basically try to document everything that happens and that you do in the workplace very carefully. Keep a diary or notes every day when you are doing some kind of action to exercise your rights, and then afterwards, so that you can have a note of when any kind of retaliation happens if it does. It's often, we also say, a good idea to do any kind of action or complaints with at least another coworker present, so they can be a witness, and so that you could have be more protected under the NLRA. And sometimes we say also, if you're going to put yourself out there by speaking up, doing something that's more kind of public and open can make it harder for your employer to later say, "Oh, we didn't know you exercised your rights, and we're firing you or disciplining you for some totally unrelated reason." That said, this all really depends on the situation that you're in, and so we strongly recommend that you seek advice from an organization like ours, or an attorney, or a labor union, or someone who has experience in this area, if you think your employer is putting your safety in danger or breaking the law. So that's it in a nutshell, your whistleblower rights and your rights to take collective action. If you have any questions about your rights or other workplace issues, please feel free to contact us. Our information is below this video. We hope you all are staying safe out there. And do please reach out to us if we can help answer any questions. Thanks for watching.